Get out of the car right now. We're not playing this game. Get out. 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 What part of that don't you understand? Hey, Drew, I'm getting arrested, Drew. I'm getting arrested. Hold on, bro. I just had surgery on my knee. I just had surgery on my knee, bro. I just had surgery. You're not going to give me your license?
I'm leaving.
Let me have your license. Your license right now.
Sir,
hey, your license right now.
I'm leaving.
Or I'm going to lock you up. Your license right now.
You're a little confused.
I'm getting out, bro.
Too late. Too late.
All right, bro. Take me to jail, bro. Do what you got to do, bro.
We are. We will.
Good.
All right, let's get into something significant today. This isn't just another traffic stop gone wrong. This is a case that puts constitutional law directly under the microscope. Tyreek Hill, one of the most explosive players in the NFL, and his teammate Calais Campbell found themselves at the center of an incident that has now escalated into a federal lawsuit against the Miami-Dade Police Department. Now here's what makes this case essential viewing. We're going to examine whether the officers acted within the boundaries of Fourth Amendment law, or whether they crossed lines that no badge can justify. I'm talking about the legal standards that govern every traffic stop in America, standards that apply whether you're a professional athlete or anyone else driving to work. We'll break down the body cam footage together, and I'll walk you through exactly what the law requires at each moment. If you want to actually understand your rights during police encounters, subscribe now. Let's get into it.
Why don't you have your seatbelt on?
Don't knock on my window.
Why don't you have your seatbelt on?
Knock on my window like that, though.
Like what? Why you have it up? We got nowhere to talk to you.
My ticket, bro, so I can go. What you gotta do?
Keep it down. Hey! Keep your window down. Hey! Keep your window down. Keep your window down, I'm gonna get you out of the car. As a matter of fact, get out of the car.
Give me that.
Get out of the car.
Give me that. We'll break that freaking window.
Get out of the car. Get out of the car right now. We're not playing this game. Get out.
Get out. Get out. Get out. Get out. Get out. Get out.
Okay, so right there, that escalated fast. What we just witnessed is the critical moment where this entire situation pivots. The officers demand to keep the window down and Hill's decision to roll it up. Now here's what you need to understand. Under Wren versus United States from 1996, the Supreme Court held that any traffic violation, no matter how minor, provides constitutional grounds for a stop. Speeding and seatbelt violations, that's textbook probable cause. But here's where the legal analysis gets complicated. Pennsylvania versus Mims established that officers can order drivers out of a vehicle during a lawful traffic stop. That's settled law. However, the manner of extraction matters enormously. The Fourth Amendment doesn't just ask whether police can act, it asks whether the force used was objectively reasonable under Graham versus Connor. What I find striking is the speed of escalation. Hill rolls up a window, and within seconds, officers are physically removing him from the vehicle. The question a court will have to answer is whether that response was proportional to the actual threat posed by a closed window.
What part of that don't you understand? Hey, Drew, I'm getting arrested, Drew. I'm getting arrested. I'm getting arrested, Drew. I'm getting out, bro. God. When we tell you to do something, you do it. You understand?
I'm getting out,
You
bro.
understand? Not what you want, but what we tell you.
I'm getting
You're a little
out.
confused.
I'm getting out, bro.
Too late.
Chill,
Too
bro.
late.
All right, bro. Take
Too
me to
late.
jail, bro. Do what you gotta do, bro.
We are. We will.
Good, bro.
It is good.
Hey, Drew, hey,
Don't worry about it. I hung up the phone. You stop crying.
bro. Y'all,
Don't move.
good. Bro, you beating on my window like you.
That right there, when we tell you to do something, you do it. Let me be absolutely clear about something. That statement reveals a fundamental misunderstanding of constitutional policing. Officers don't have unlimited authority to issue commands during a traffic stop. Under Terry versus Ohio from 1968, the Supreme Court established that investigative detentions must be reasonably related in scope to the circumstances that justified the initial stop. What exactly was the safety justification here? A rolled up window? Hill is telling them he's getting out. He's complying. And the officer's response is, too late. Too late for what? Too late to exercise your constitutional rights without physical force? Here's what bothers me deeply. The command to stop crying while pressing someone into the ground. That's not de-escalation. That's domination. And the law doesn't sanction domination. Graham versus Connor requires us to evaluate the severity of the crime at issue and whether the suspect poses an immediate threat. Speeding and a seatbelt violation don't justify this level of physical intervention when the person is actively stating compliance.
Y'all beating on my window like y'all crazy for.
Damn, yo, bro. Bro, dude, beating on my window like he crazy. I ain't do nothing, twin. Dang. Hold on, pull to the side, bro.
Hey, don't park there. Don't park there.
Hey.
You're doing it now, coach.
Hold on, twin, hold on, bro. I just had surgery on my knee. Bro. I just had surgery on my knee.
No. Did you see that? Another officer just launches at his knee while he's screaming about surgery. This is where Graham v. Connor becomes absolutely critical. The 1989 Supreme Court decision tells us that force must be evaluated from the perspective of a reasonable officer on scene, but it also demands proportionality. What crime justifies a second takedown? What threat did Tyreek Hill pose while already restrained on the ground? The Graham factors ask three questions. Was there a severe crime? Was there an immediate threat to officer safety? Was the suspect actively resisting or attempting to flee? A man in handcuffs screaming about a knee surgery satisfies none of these. Zero. And here's what the footage doesn't tell you. Hill had undergone medical procedures. The officers had no way of knowing what damage they could inflict by targeting his lower body. This isn't just excessive force doctrine anymore. This enters deliberate indifference territory. When someone verbally communicates a medical vulnerability, and you respond by attacking that exact vulnerability, you've crossed from negligence into something far more serious. The Fourth Amendment demands better than this.
I just heard you in your ears when we go there. Put your window down.
Chill, bro. Hey, don't do, bro.
Back up.
Hey, call Drew. Hey, call Drew, bro. Hey, call Drew, bro. Hey, what? Hey, call Drew, bro. Just call Drew. Hey.
I'm not doing anything. I'm not doing nothing. What am I doing that's wrong?
Hey, listen.
Take it back in the Hey, listen. Hey, man, they got Tyreek. The cops over here beating on him, man. They over here beating on Tyreek, man.
And now they're driving his friends away while he's pinned to the ground. Look at this. Here's what people need to understand about medical disclosures during police encounters. Under City of Revere versus Massachusetts General Hospital from 1983, the Supreme Court established that police have a constitutional duty to provide medical care to individuals in custody. The moment Tyreek Hill verbalized that knee surgery, his medical status became legally relevant information that officers were obligated to consider. This creates a significant problem for the qualified immunity defense these officers will inevitably raise. Qualified immunity protects officers unless they violated clearly established law. Well, the law is clearly established here. The 8th and 14th Amendments require custodial officers to respond reasonably to known medical conditions. Ignoring a verbal disclosure of recent surgery while applying force to that exact body part, that's not a gray area. In Calais Campbell trying to help? The Ninth Circuit in Gravelette Blondine versus Shelton recognized that bystanders have First Amendment rights to observe police activity. Driving away witnesses who could provide medical context doesn't just look bad, it compounds the liability exposure exponentially.
Straight up the side on the side of the
Hey, get in the car. You're parked at the middle of the street.
I'm in the car.
You gotta go before you get a ticket.
Hey,
I'm
you're
not
in the car.
Who's the driver?
This is my car.
All right, move.
I'll take that.
You gotta move right now. Let me have your license. You're gonna ticket too.
I'm coming.
Let me have your license. You're gonna ticket. Let me have your license.
I'm leaving.
I'm not playing. Let me have your license.
Leaving. Yo, what's
your
going
license
on?
right now.
What's going on?
Your license right now. You're not gonna give me your license.
This is getting worse by the second. Listen to what just happened here. The friend parks nearby because he's concerned about what's going on, and the officer immediately escalates into demanding a license from someone who wasn't even driving. Let me be absolutely clear about bystander rights during police encounters. Under City of Houston v. Hill from 1987, the Supreme Court held that citizens have a constitutional right to verbally challenge police officers. That includes asking questions. That includes expressing concern for someone being detained. Now, what does the law actually require of bystanders? They cannot physically interfere with an arrest. They cannot obstruct officers from performing their duties. But parking nearby, asking what's happening to your friend, that is protected speech and protected presence under the First Amendment. Here's where this officer crossed the line. Demanding identification from a bystander requires reasonable, articulable suspicion that the bystander has committed or is about to commit a crime. Being concerned about your friend is not a crime. Standing on a public street is not a crime. The officer created a confrontation where none needed to exist. This is textbook escalation of a situation that lawful policing would have de-escalated.
Your license. Your license right now.
Sir,
Hey, your license right now.
I'm leaving.
Or I'm gonna lock you up.
just told
Your
me to
license
leave.
right now.
He just told me to
Your
leave.
license right now.
Sir, you just-
You're dealing with me now.
Sir.
Your license right now. We're not playing this game here, man.
Let's man go, man. My license in my bag. Let me get my
All right,
bag.
go get your license.
Let me get my bag.
The tone here is wild. Your license right now, repeated like a drill sergeant, while simultaneously telling him to leave? Pick one. You cannot legally threaten someone with arrest and also tell them to go. That's not law enforcement. That's intimidation theater. Here's what the public gets wrong about these situations. There's this myth that you must comply instantly with every police demand or you're committing a crime. That is fundamentally false. Under Heibel v. 6th Judicial District Court from 2004, the Supreme Court held that stop and identify statutes only apply when police have reasonable suspicion of criminal activity. Being someone's friend at a traffic stop is not criminal activity. And did you catch the confusion? He just told me to leave, while the officer simultaneously demands identification. The friend is trying to understand contradictory commands, and he's being threatened with arrest for that confusion. Courts have consistently held in cases like Glick v. Kniff that officers cannot manufacture compliance failures through conflicting orders and then punish citizens for the chaos police themselves created. This is procedural entrapment disguised as law enforcement.
Players to the game. They got Tyreek handcuffed on the top, pushing his face into the ground. They got him on the ground and being Calais out here right now, man. So the cops being ridiculous, man. He telling me to get my car. He just took my license. I pulled over. My teeth, they get his face pushed on the ground. They drew, man. This is ridiculous. But one of my teammates, man, he recorded it going up here with me. Hey, Calais.
Listen to what that man is documenting in real time. They got him on the ground. They're being ridiculous. This is a witness creating a contemporaneous record of what he's seeing, and that matters enormously in federal court. Here's what most people don't understand about failure to comply charges. Under Florida Statute 316.072, officers can issue lawful orders related to traffic control, but the key word is lawful. The burden of proof falls on the state to demonstrate that the order was legitimate and that the defendant willfully disobeyed it. Rolling up your window during a traffic stop? Courts have never definitively ruled that constitutes obstruction or failure to comply. And watch what happens with these charges. He'll receive citations for careless driving and a seatbelt violation. Those citations were dismissed in November 2024 when the charging officers failed to appear in court. Failed to appear. If this was such a clear-cut case of dangerous noncompliance, why didn't a single officer show up to testify? That tells you everything about whether due process was actually followed here. The arrest happened, but the legal justification evaporated the moment it faced judicial scrutiny.
I'm not going nowhere. I'm right here.
No. He's driving reckless and back behind the turnpike.
Man, all of this is uncalled for, man. All
he had to do.
Why is he getting arrested? Why is he getting arrested?
What's your name?
Janu, why is he getting arrested though?
If we stop you and you don't identify yourself to the police, we have to get you out of the car, and that's what happened.
Him? I'm talking about him. I'm talking about him. My other teammate. Why is he getting arrested?
I don't know what happened there. You guys gotta listen, man. If we tell you, hey, back up, or give me your ID, or stop, just gotta listen and everything's fine.
Did you catch that explanation? If we stop you and you don't identify yourself to the police, we have to get you out of the car. That's the official justification being offered, and it's completely disconnected from Department of Justice guidelines on use of force. The DOJ's 2017 Principles for Promoting Police Integrity explicitly state that force should only escalate when officers face active resistance or genuine safety threats. Rolling up a window is not active resistance. It's passive noncompliance at most. Here's what should have prevented this escalation. Departmental policies typically require verbal warnings and de-escalation attempts before physical intervention. The 2022 DOJ guidance on traffic stop protocols emphasizes proportionality and officer restraint precisely to avoid situations like this one. Where was the supervisor? Where was the training that teaches officers to distinguish between someone who poses a threat and someone who's merely inconveniencing them? These aren't abstract questions. They're the institutional failures that allowed a traffic stop to become a federal lawsuit. The checks existed on paper, but clearly failed in practice.
I just had surgery on my knee. Bro. I just had surgery on my knee, bro. I just had surgery in your ears when we come here with you. Chill, bro. Hey, don't do, bro. Back up. Hey, call through. Hey, call through, bro.
Surgery on his knee. He's telling them he just had surgery on his knee and they're still forcing him down. This angle shows exactly what we need to understand about body cam footage as an accountability tool. Without this recording, none of us would know that Hill verbally disclosed a medical vulnerability while officers continued applying pressure. That documentation is why the Miami-Dade Police Department is now facing a federal lawsuit filed in April 2026. Here's the dual nature of body cam evidence. It protects officers from false accusations when they act lawfully, and it exposes constitutional violations when they don't. This footage does both simultaneously. We see officers responding to what they perceived as noncompliance, but we also see the complete breakdown of medical acknowledgement protocols. The transparency cuts both ways. Privacy advocates worry about sensitive moments being broadcast publicly, but recordings like this serve the greater public good when they reveal the gap between departmental policy and street-level execution. What you're watching isn't just evidence in Hill's lawsuit. It's exactly why the Miami-Dade Police Department announced they were reviewing their traffic stop procedures. Bodycam footage turned a he said, she said dispute into an objective record that neither side can dismiss.
Bro, so how come nobody holding him but you holding me? You see that? Look, turn around, look. Hey, bro, you grabbing my shoulder too hard.
Oh, man. Did I fucking tell you to stop moving?
Hey, yo, hey.
I just told you to stop moving, but you want to play victim here.
This is uncomfortable, though.
Okay?
You don't understand
I told
how
you,
uncomfortable
sit
it is.
upright. There you go. Sit upright and that's it, right?
I'm going to tell you like
Stop
this, bro.
moving.
Look, your job is to serve and protect, right? You're doing a horrible job of protecting right now, bro. I told you I'm not going to run nowhere. For what? What am I going to... That's only going to make this matters worse.
Your job is to serve and protect. You're doing a horrible job. That statement from Tyreek Hill while pinned to the ground is exactly why the Miami-Dade Police Department announced policy reviews in early 2026. When a citizen can articulate the failure of constitutional policing better than the officers can justify their actions, that's institutional breakdown. Here's what this footage represents beyond just one incident. The federal lawsuit filed in April 2026 alleges a pattern, not an anomaly. And historically, when departments face this kind of documented misconduct, they either reform voluntarily or courts impose consent decrees, like we saw with Ferguson after Michael Brown and Baltimore after Freddie Gray. The legal pressure isn't theoretical anymore. Hill's lawsuit seeking punitive damages creates financial incentive for systemic change. Municipalities pay settlements from public funds, and taxpayers eventually demand accountability. What emerges from cases like this becomes binding precedent. Future officers in the 11th Circuit will be trained on whatever ruling comes from Hill v. Miami-Dade. That's how one traffic stop reshapes policing for an entire region. The doctrine evolves because someone with resources refused to accept that's just how it is.
Dude, tackle me on my... Alright. Why he really hit me on my knee on this seat and shit.
What happened?
No, so look, he told me to pull over, right? And I pulled over, he was like, why ain't your seatbelt on? I'm like, sir, was I speeding? He was like, nah. He was like, yeah, you were speeding. I'm like, sir, I was going 55 in a 40. Okay, that's cool. I was like, okay, write me a ticket. Write me a ticket so I can go. He was like, so like he started walking away. I let my window back up and I put my seatbelt on, right? So he was like, oh, put your window. I said, I'm not gonna put my window down, bro. I'm not, bro. I'm finna call Drew. So I called Drew. You know Drew Brooks, right? So I called Drew to make sure everything was straight. He started getting hostile. He's like, get out the car, get out the car. I said, bro, for what? Let me call Drew first. Give me 1 second, sir. I never once got out of control or nothing. But then they pulled me out the car, slammed me on my knee, and he fought. No, I got tendonitis again, bro. Okay. Like my whole knee.
Okay. All right.
So really, bro.
Yes.
Hey, can you take these off me though, please?
Now we're hearing Hill's own account to the supervisor, and this is where his civil lawsuit gains traction. Under Section 1983 of the Civil Rights Act, Hill must prove two things: that officers acted under color of state law, and that they violated a clearly established constitutional right. The first element is automatic. They wore badges. The second element is what makes this case legally fascinating. The burden of proof in civil rights claims operates under a preponderance standard, meaning Hill must show it's more likely than not that violations occurred. That's a lower bar than criminal cases, and what he just described, being struck with a baton while already detained, physical force applied after compliance was offered, those allegations map directly onto Fourth Amendment excessive force violations. Here's where precedent matters. In Kingsley v. Hendrickson, the Supreme Court held that objective unreasonableness determines excessive force claims, regardless of the officer's subjective intent. Hill doesn't have to prove malice. He has to prove no reasonable officer would have acted this way given identical circumstances. If this case produces a ruling, it could establish binding precedent on window compliance and force escalation throughout the 11th Circuit. That's not small. That's doctrine.
Come on, bro. Ass cop, bro. Look at that bitch.
All right, come over here. Don't fall off the sidewalk.
They tough, bro. Like, no, bro. Damn, this dude here. Man, I'm already rich. I don't need. Come on, bro.
Open your legs.
Like, damn, look, you see what he said? Open your legs.
Just let them lean forward a little.
These pops are weird.
Just go with the ring. Just go with it.
Okay, you right. Almost over. You right.
Let me stop here and address something bigger, because this case has exposed myths that millions of Americans still believe about their obligations during traffic stops. Myth number 1. If you don't immediately comply with every police command, you deserve whatever happens next. That is legally false. Under Glick v. Kniff from the First Circuit and subsequent holdings, citizens retain constitutional protections even during lawful detention. Compliance reduces risk, but non-compliance with an unlawful order is not a crime. Myth number 2. You cannot record police during a traffic stop. Wrong. The First Amendment protects your right to document police activity in public spaces. This has been affirmed in multiple circuits, including Turner v. Driver in the Fifth Circuit. Myth number 3. Rolling up your window constitutes obstruction. No court has established this as binding precedent. A closed window is passive behavior, not active resistance. Here's what the law actually requires during a traffic stop. Provide license registration and insurance when requested. Exit the vehicle if ordered under Pennsylvania v. Mims. That's it. Everything beyond that exists in a constitutional gray zone where your rights still matter.
Hey,
Hold on, man.
thank you.
Hold on.
All right. Appreciate it, bro.
Hold on.
Thank you, guys. You okay? No, I'm not, bro. I'm finna go home, bro. These cops.
Hey, I need to pick for a second. Go pick it, man. Okay.
And there it is. Superior officers arrive and suddenly the cuffs come off. That moment right there tells you everything about accountability in American policing. When supervision shows up, the calculus changes immediately. Now here's where we pivot to the consequence phase, because this is where qualified immunity enters the conversation. Under Harlow v. Fitzgerald from 1982, officers are shielded from civil liability unless they violated clearly established constitutional rights. But here's what the public misunderstands about qualified immunity. It was never designed to protect officers who ignore medical disclosures and escalate force against compliant suspects. The officers involved in this stop now face career-defining scrutiny. Internal affairs investigations can result in suspension, termination, or mandatory retraining. But the federal lawsuit filed in April 2026 changes their exposure entirely. If Hill's legal team proves objective unreasonableness under Kingsley, the individual officers could face personal liability, depending on how the court rules on qualified immunity. The judicial pathway here runs through Section 1983 litigation in federal district court. Discovery will compel officer depositions and departmental communications. This is how systemic reform actually happens, not through voluntary policy changes, but through litigation that forces institutional transparency.
Take a picture of that officer, too.
Don't worry, it will be. I'll get
That's all I need. That's all I need. Thank you.
Do me a favor, just let me get it.
Hold on, let me talk to my mom real quick.
So what are we walking away with here? This case isn't just about Tyreek Hill or Calais Campbell. It's a constitutional masterclass disguised as a traffic stop gone wrong. First takeaway, know your obligations. You must provide license registration and insurance. You must exit the vehicle if ordered under Pennsylvania v. Mims. Beyond that, constitutional gray zone where your rights still apply. Second takeaway, documentation matters. That body cam footage transformed a he said, she said dispute into federal litigation. Record when you can. Witnesses matter. Contemporaneous evidence wins cases. Third takeaway, compliance reduces risk but does not eliminate rights. You can refuse unlawful orders and still retain Fourth Amendment protections. The law does not require you to abandon your constitutional standing because someone wears a badge. Fourth takeaway, accountability comes through litigation, not voluntary reform. The Miami-Dade Police Department is reviewing traffic stop procedures right now because of this lawsuit. That pressure came from legal action, not from internal conscience. Stay educated. Understand your rights before you need them. The law belongs to all of us, not just those who enforce it.
I don't know why I'm here.
You know what I mean? Then he can move the car.
You know exactly why you're here.
It's called fail to obey. We gave you a lawful command to do it. You didn't do it, sir. So now you're under arrest for failure to obey.
Failure to obey.
Yes, we gave you a lawful command.
He told me I have to move my car.
And did you ever move the car after multiple times of being told
He told
no,
me just now.
sir?
He said, if you don't want to come, I'm going to arrest you.
You didn't. Standing there recording.
How many times I told you to leave, man?
You didn't listen.
It's
Okay?
okay.
Even, hear me out. I was the last one to get here. You know that, right? So when I get here, I don't know what's going on, but I hear them telling you multiple times, move the vehicle, move the vehicle, move the vehicle, and you don't do it. What's your ID?
Thank you for watching this entire breakdown with me. I mean that genuinely. You didn't just watch a video, you sat through constitutional analysis of Terry stops and Graham factors and qualified immunity doctrine. That takes intellectual commitment, and I respect it. This channel exists because informed citizens make better decisions during police encounters and better voters when police reform is on the ballot. Every case we analyze together adds to your legal toolkit. If this breakdown helped you understand something you didn't before, subscribe. Hit that notification bell. We do this regularly. Body cam footage, depositions, court rulings, all examined through a legal lens that respects your intelligence. Drop your questions in the comments. What cases do you want analyzed next? What legal doctrines confuse you? Tell me where you want to go deeper, because I'm building this content for you. The Tyreek Hill case will evolve. Discovery will produce documents. Depositions will create testimony. Qualified immunity rulings will establish precedent. We'll be here to break all of it down. Stay informed, know your rights. I'll see you in the next one.
What is? Y'all know these are Dolphin players, right?
They want to play games and they want to act up, and this is where we are. How many times did we not tell him to move his car?
I know, but he's looking out for his team.
Right? Hold on, hear me out. How many times did we not tell him to move the car? Okay?
I know,
You
but
didn't
they're
listen.
looking out for their teammates.
I understand that, but if an officer is giving you a lawful
I
command,
got you. No, I understand.
you got to do the
But y'all know
lawful
that's
command.
Tyreek, though, right?
Yeah, I absolutely know who that is,
So
right?
what happened?
I don't know. I was the last one to get here. Did you not see that my motorcycle was the last one here? You're good to go, man. Come on. What?
Hold on. I need you to hear what just happened because this changes everything about how we understand what these officers were thinking. That conversation right there, they want to play games and they want to act up. That language is not the language of constitutional policing. That is the language of ego. That is the language of officers who view noncompliance as personal disrespect rather than a legal question requiring proportional response. And then the most revealing moment of this entire case. One officer asks, "How many times did we not tell him to move his car?" And another officer responds with something extraordinary. He says, "I understand, but if an officer is giving you an unlawful command, you gotta do the unlawful command." Let that sink in. An officer just articulated out loud the unconstitutional premise underlying this entire encounter, the belief that citizens must comply with unlawful commands. That is not how the Fourth Amendment works. That is not how any constitutional framework works. The Supreme Court in Colander v. Lawson back in 1983 made clear that vague or standardless commands cannot create criminal liability. You cannot arrest someone for failing to obey an order that was never constitutional to begin with. And then the recognition. Y'all know that's Tyreek though, right? And suddenly the tone shifts. You're good to go, man. The same officers who moments earlier were discussing playing games and acting up suddenly become accommodating when they realize who they're dealing with. This is the constitutional problem in its purest form. Equal protection under the 14th Amendment means the law applies identically, regardless of celebrity status. An anonymous citizen rolling up their window has the same Fourth Amendment protections as a millionaire NFL receiver. The fact that recognition changes officer demeanor suggests a two-tiered system of rights enforcement that violates the foundational premise of American constitutional law. Let me connect this to everything we've analyzed today. We started with a traffic stop for speeding and a seatbelt violation. Under Wren, that stop was constitutional. But what happened after the stop? Force escalation against passive noncompliance, continued physical pressure despite disclosed medical vulnerability, detention of a bystander exercising First Amendment rights, contradictory commands designed to manufacture compliance failures. Every step of that escalation failed the Graham versus Connor proportionality test. Every step ignored DOJ guidance on de-escalation. Every step created additional liability exposure that will now be litigated in federal court. The April 2026 federal lawsuit alleging civil rights violations is not about one bad traffic stop. It's about whether qualified immunity can shield officers who ignore clearly established constitutional principles. Under Kingsley versus Hendrickson, the question is objective reasonableness. Would any reasonable officer facing a closed window during a speeding stop immediately resort to physical extraction? Would any reasonable officer continue applying force to an area where the suspect just disclosed surgical injury? Would any reasonable officer detain a bystander for parking nearby and asking questions? The answers to those questions will establish precedent throughout the 11th Circuit. What happens in this case will define the boundaries of lawful force escalation for millions of Americans. And that bystander in the clip who said professional players shouldn't be treated like that? He's wrong on the framing, but right on the substance. It's not about professional players. It's about citizens. All citizens. The Constitution doesn't care about your jersey number or your contract value. It cares about whether government agents exercise their power within constitutional limits. This case matters because it forces judicial scrutiny of assumptions that too many officers hold. The assumption that non-compliance justifies escalation. The assumption that control must be established immediately, regardless of threat level. The assumption that citizens owe instant obedience to every command, regardless of its constitutional validity. Those assumptions are wrong. And when they're wrong, in cases with body cam footage and legal resources to pursue litigation, they get corrected through binding court precedent. That's what we watched today. Not just a traffic stop, a constitutional stress test that will reshape policing doctrine. Tell me your name and where you're watching from. Drop it in the comments. I want to know who's building their legal knowledge with me. I'll see you in the next one.